C2C contends that MAXIMUS has an impaired objectivity OCI by holding both the Administrative Qualified Independent Contractor AdQIC task order through Q2A and the Qualified Independent Contractor QIC task order. The protester describes the conflict as follows. The SOW, Statement of Work, duties of the AdQIC conflict with the loyalty they have for their own company or parent company and the duty of objectivity owed to CMS. As the AdQIC, MAXIMUS, is financially motivated to withhold issues regarding its own processing of QIC reconsiderations while at the same time emphasizing to CMS any discrepancies or aberrancies in the reconsideration processing of its competitors, including C2CS, or any other non-affiliated QICs. MAXIMUS selective notifications of questionable processing to CMS tarnish the reputation of their competitors and help MAXIMUS gain corporately when the task order is recompeted. The FAR provides that an OCI exists when, because of other activities or relationships with other persons or organizations, a person or organization is unable or potentially unable to render impartial assistance or advice to the government, or the person's objectivity in performing the contract work is or might be otherwise impaired, or the person has an unfair competitive advantage. Under the FAR, contracting officers are required to identify and evaluate potential OCIs as early in the acquisition process as possible, and avoid, neutralize, or mitigate significant potential conflicts of interest before contract award. The responsibility for determining whether an actual or apparent conflict of interest will arise, and to what extent the firm should be excluded from the competition, rests with the contracting officer. We review the reasonableness of a contracting officer's OCI investigation and, where an agency has given meaningful consideration to whether a significant conflict of interest exists, we will not substitute our judgment for the agency's, absent clear evidence that the agency's conclusion is unreasonable. In this regard, the identification of conflicts of interest is a fact-specific inquiry that requires the exercise of considerable discretion. A protester must identify hard facts that indicate the existence or potential existence of a conflict. Mere inference or suspicion of an actual or potential conflict is not enough. Nonetheless, once it has been determined that an actual or potential OCI exists, the protester is not required to demonstrate prejudice. Rather, harm from the conflict is presumed to occur. Subpart 9.5 of the FAR, and decisions of our office, broadly identify three categories of OCIs: biased ground rules, unequal access to information, and impaired objectivity. The primary responsibility for determining whether a conflict is likely to arise, and the resulting appropriate action, rests with the contracting agency. Once an agency has given meaningful consideration to potential conflicts of interest, our office will not sustain a protest challenging a determination in this area unless the determination is unreasonable or unsupported by the record. The protester contends that, as the AdQIC, MAXIMUS, through its wholly owned subsidiary Q2 administrators, is authorized to make referrals to the Appeals Council of administrative decisions that overturn or partially overturn reconsideration decisions made by MAXIMUS, an ability also acknowledged by the agency and the intervener. Although this structure presents hard facts that indicate a potential conflict of interest, in that Q2A is in the position of reviewing requests for further appeal of decisions issued by Q2 as parent, the parties disagree as to whether this is properly an impaired objectivity OCI, and if so, whether there are factors that mitigate the inherent conflict. As relevant here, an impaired objectivity OCI exists where a firm's ability to render impartial advice to the government will be undermined by the firm's competing interests, such as a relationship to the product or service being evaluated. CMS and MAXIMUS assert that, despite the relationship between MAXIMUS and Q2A, no OCI exists because the AdQIC is examining only the sufficiency of the intervening Level 3 ALJ review. During the pendency of this protest, CMS re-examined MAXIMUS potential OCIs in light of C2CS allegations. The agency concluded that there was no potential OCI if MAXIMUS and its subsidiary served concurrently in the QIC and AdQIC roles because the AdQIC does not have formal responsibility for performance evaluation of the QICs. CMS also relied on MAXIMUS' own conclusions as to the absence of any conflict. Our office has explained that a firm's participation in work that could affect its own interests or the interests of its competitors can give rise to an impaired objectivity OCI. The record indicates that the agency did not give meaningful consideration to the potential impaired objectivity OCI involving Q2 and MAXIMUS dual roles as the AdQIC and the QIC. We think that the structure here, where the AdQIC can refer for further review ALJ decisions that overturn a QIC reconsideration, could present the opportunity for the AdQIC to offer biased recommendations. The record shows that here, CMS did not investigate whether the presence of related firms operating within the same chain of review created an impaired objectivity OCI. In this regard, the agency characterized the AdQIC role as merely reviewing ALJ decisions, sidestepping the fact that the ALJ decision is itself a review of the QIC reconsideration. Furthermore, the substance of the agency's inquiry was limited to whether the AdQIC participated in the performance evaluations of the QICs. CMS relied on the contractor's own OCI conclusions as to the absence of any other conflict. Because the record shows that the agency has not meaningfully examined whether Q2A, in essence, MAXIMUS itself, could render objective advice to the agency while simultaneously serving as both the QIC and the AdQIC, we sustain the protest.